What's up, everybody? Welcome back into another episode of The Lawyer You Know. And we have a lot to talk about today. We are going to go through Judge Cannone's thoughts on her order denying the motion to dismiss, which I always love when judges go into detail either with what they say in open court or what they put in a rather long motion, hitting so many topics and issues that we've seen on the case because we get the view of how do they really see it? How do they view this case? And we get that answer as we read through her order. And then we will talk about, in an absolutely shocking case, this might be the most shocking thing that's happened. I don't think it's going to have as big of an effect as some other shocking moments that have happened, but a juror who was on the Karen Reed trial 1 jury and then picked to be an alternate, so did not deliberate, did not sit there for the hung jury, has now entered an appearance to be Karen Reed's defense lawyer. She has joined the defense team. We'll talk about what we know about that juror, what she has said in the past, and what we think this actually means, and answer some of the questions that have been coming out online that I think are fair questions at this point about what's going on. So with all this happening, it's good news and bad news. Unfortunately, today I have a hard stop at 3:30 because I have a call at 3:30 I have to make to a client. So we have 1 hour and we have this motion to dismiss and we have the new lawyer to get to. So I want everybody to be in here when we talk about the new lawyer. I want to get all their questions in. So what I'm going to do is probably about 30 to 45 minutes we're going to spend here on this motion to dismiss, on what Judge Cannone had to say. Then we'll take a break. We'll talk about the lawyer situation for a while. And then if we have time before 3:30, we'll stop at 3:30 at the end of the motion to dismiss. However far we get. Sorry, I got distracted because Bodhi said she's a lawyer. That was misspeak. She is a lawyer. There was a lawyer on the main jury. She was an alternate, so she didn't deliberate, and she just joined the defense team. So it's insane, something I've literally never seen before, never heard of happening before. We'll talk about whether there are conflicts, whether there are issues, and answer the questions that I'm sure you guys have. But I'll give you some time to throw those in the chat, as well as we get to see behind the curtain a little bit about how Judge Cannone is making her decisions, because we see how she views the evidence in the case. So first, let's get to the discussion. We already read page 1 yesterday where it said why overall why she dismissed the case, or why she denied the charges, the motion. Dismissal of criminal charges with prejudice is the most severe sanction that the court can impose in a criminal case to remedy misconduct on the part of the Commonwealth. I agree. The dismissal of a criminal case is a remedy of last resort because it precludes a public trial and terminates criminal proceedings. I agree. Absent egregious misconduct or at least a serious threat of prejudice, the remedy of dismissal infringes too severely on the public interest in bringing guilty persons to justice. I agree. A dismissal with prejudice for government misconduct is very strong medicine, and it should be prescribed only when the government misconduct is so intentional and so egregious that a new trial is not an adequate remedy. I agree. So we agree with the standard and how it should be done. We all agree there. 2 parallel legal principles govern the resolution of cases involving prosecutorial misconduct where dismissal is contemplated. First, where the prosecutor fails to disclose evidence that the defendant is entitled to receive and the defendant is prejudiced by the failure to disclose, a motion to dismiss should not be allowed absent a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. Such a drastic remedy would be appropriate where failure to comply with discovery procedures results in irremediable harm to a defendant that prevents the possibility of a fair trial. Alternatively, in rare circumstances, prosecutorial misconduct that is egregious, deliberate, and intentional, or that results in a violation of constitutional rights may give rise to presumptive prejudice, and the drastic remedy of dismissal charges may become an appropriate remedy. The latter theory should be narrowly applied and confined to situations where the misconduct has cast such doubt as to position the entire investigation, and a stronger deterrent is warranted to prevent repetition of such misconduct. So that right there, the last part is, this investigation was so bad that we need to do something to send a message that this is not how it works in Massachusetts. This is not how it works in America. That would have been the defense's best chance to win, in my opinion, because overall, the way the case law speaks to most of this, which maybe we need a change in that, right? Maybe it's just too deferential to law enforcement and prosecutors. But generally speaking, because there is a second trial, I would say more than 50% of judges would do exactly what Judge Cannone did in denying this motion to dismiss and allow a second trial, because they say so much of this has been remedied because the discovery has now been turned over. But when we read some of the footnotes and we really dig in here, we're going to see some major things we disagree with. The defendant here argues the Commonwealth committed egregious discovery violations by destroying and or withholding exculpatory evidence, and that a Massachusetts state trooper interfered with the jury during the first trial, warranting dismissal of the charges. As discussed below, the defendant has not demonstrated that she suffered any prejudice. That's kind of wild. Any prejudice as a result of discovery violations that cannot be cured by her new trial, and has not substantiated her claims regarding interference with the jury, which, as discussed in detail below, are baseless. Baseless. That's a shot. The due process clause of the federal constitution and Massachusetts Declaration of Rights require the Commonwealth to disclose to a defendant material exculpatory evidence. That's Brady. Evidence is exculpatory if it provides some significant aid to the defendant's case. Not means you will win every single time, right? It just has to provide some significant aid to the defendant's case. Now, it does say significant. It doesn't just say any aid. Whether it furnishes corroboration by the defendant's story, calls into question a material, although not indispensable element of the prosecution's version of the events, or challenges the credibility of a key prosecution witnesses. Ding, ding, ding. Exculpatory material is subject to automatic disclosure, meaning you do not have to ask for it. But what's Brady and what's not? We'll see what Judge Cannone says. The Commonwealth's duty to disclose exculpatory evidence in criminal defendants' cases is further reflected in Massachusetts Rule of Criminal Procedure and Rule of Professional Conduct. They have to do it, okay? Duty to disclose derives from the core responsibilities of a prosecutor. We know that. Rule 14, which is the discovery rule in Massachusetts, is another rule that's at play here. The rule in effect at the time of the discovery issues here provides that the prosecution shall automatically disclose to the defense certain evidence relevant to the case and in the possession, custody, or control of the prosecutor, persons under the prosecution's direction or control, which would be MSP, or persons who have participated in investigating or evaluating the case, that would be the lead investigator. This includes any facts of an exculpatory nature and material relevant to police reports, photographs, tangible objects, all intended exhibits, reports, physical examination, and person or of scientific tests or experiments, et cetera, et cetera. Provides that even when a party has provided all the discovery required by Rule 14 or a court order, shall file with the court a certificate of compliance stating the best of its knowledge, and after reasonable inquiry, the party has disclosed and made available all items subject to discovery. So that last section is exactly why the last section is exactly why discretion is something that people struggle with. When you leave it open and you say, I did it to the best of my ability, the judge has to look at it and say, did you really make reasonable inquiry? Is this the best you could have done? So let's go into the surveillance footage. Factual background. So these are the facts as Judge Cannone believes them to be true based on all the information she has. On January 29, 22, after O'Keefe was found dead in the snow outside the Albert residence in Canton, police towed the defendant's vehicle to Canton PD. There were multiple surveillance cameras used at the CPD that captured the defendant's vehicle on a flatbed tow truck as it entered the Sallyport at 5:30 p.m. There was also cameras inside the garage where the vehicle thereafter remained. According to the Commonwealth, surveillance footage from those cameras is automatically overwritten on a regular basis. Footage from the night in question was not lost, however, because CPD Sergeant DG followed his customary practice of downloading the recording to a hard drive in 6-hour segments. So the judge is making a finding here that video footage was not lost forever. And Sergeant D did what he's supposed to do and downloaded it to a hard drive. On February 2nd, the defendant was charged with manslaughter, motor vehicle homicide, and leaving the scene of personal injury or death. That day, the defendant filed an emergency motion for preservation of evidence pertaining to certain specific evidence in connection with the charges, which was granted. The preservation order sought to preserve all physical evidence, including any present on or near the decedent at the time the body was discovered, anything found at the alleged crime scene. I want to read this footnote here, but I don't want to lose our train of thought, so we'll go back to it. The lead investigator in the matter, Michael Proctor, by the way, she doesn't say former trooper, she says MSP trooper, took possession of the requested CPD video of the Sallyport, but did not turn it over to the prosecutors. Instead, for reasons unclear on the record, he kept the material in his case file. Let's read this real quick. Evidence in the development of a checklist of exculpatory evidence provide guidance to practitioners. Wait, this isn't the one I wanted to read. No, this isn't the one I wanted to read. Okay. On June 9th, a Norfolk County grand jury indicted the defendant on charges of M in the second degree manslaughter, etc. And the court issued an order directing the Commonwealth to provide the defense with all crime scene photographs and or videos taken in connection with the case, including but not limited to photographs documenting the purported recoveries of pieces of white and red plastic outside the residence located at 34 Fairview on January 29th and February 4th, including the metadata associated with these photographs. So that was on October 5th. That was more than 30 days after. So theoretically, it would have been overwritten, except that the judge found that it wasn't overwritten. In fact, it was saved, as it should have been. And Proctor had it, but didn't turn it over. So regardless of what she thinks the initial request was, because it seems like she doesn't think this initial request on February 2nd included video, it was saved. It was ordered by the court. It was not turned over. MSP, Proctor, violated a court order. That's what this sounds like to me. Will Judge Cannone have grave concern about that? Several months later, in June of 23, Proctor asked CPD whether it had in its possession any exterior Sallyport video showing the defendant's vehicle on the flatbed tow truck on January 29th. In response, CPD gave state police the video from the main driveway side exterior Sallyport camera. Proctor took possession of this video, but again, for reasons unexplained. Really? We don't know the reasons. We can't infer any reason. There's not a reasonable inference to be made from this evidence. Did not turn it over to the prosecutors. At some point, we've got to call a dirty cop, right? We can't just say, he did X, Y, and Z. He said X, Y, and Z. We have proof of how he felt and spoke about this case, and he had evidence, but we don't know why he didn't turn it over. At this point, I think we can infer some negative connotation as to why Proctor did or didn't do what he did and didn't do. Instead, he placed in his case file. This footage shows the exterior of the Sallyport when the defendant's vehicle was brought into the CPD garage. The recording is dark, blurry, and grainy, and the condition of the passenger side taillight, a significant issue and dispute, cannot be discerned. So, by the way, she also says in the footnote, it's unclear why Trooper Proctor requested the footage at this time. Why do we think? Okay. And this is why people have so much fire to their cover-up and their conspiracy. It's like everybody seems okay with keeping things in the dark and not getting answers. It's like, why don't we get Trooper Proctor in here? The judge has forced other people to come in here. Why don't we get him in here and ask him why? Why didn't you put it where it should be? Why did you hide it in your case file? Why did you ask for this footage? Let's get answers to at least put that to bed. If, a lie kept uncorrected becomes the truth, as Brennan said, better be careful about what's becoming the truth in this case. On February 1st, 24, Proctor testified before a federal grand jury investigating the investigation into John O'Keefe's death. So we know that's what the grand jury was about, but we don't know a lot of details. 3 months later, April 4th, 24, Lally received Proctor's federal grand jury testimony. After reading it, Lally's like, are you in possession of video footage referenced therein? In response, Proctor gave Lally the Sallyport front wall camera footage provided to Proctor in February of 22, so over 2 years later. But what he didn't give is all the video he had, but not the main driveway side exterior Sallyport footage provided to Proctor in June of 23. Lally immediately turned over the Sallyport front wall camera footage to the defense, along with footage from the CPD main driveway showing the SUV on the flatbed. None of this footage contained a view of the back of the defendant's SUV. So listen, she's giving him the benefit of the doubt. Is that frustrating to people? Yes, I'm sure it is. But it's even more frustrating when you think if the shoe was on the other foot and the defense just didn't turn something over, do we think she would have said, well, we're not sure why they didn't do it? Well, we don't know why they even requested it. She would be throwing in certain language, in my opinion, in these paragraphs to reprimand them, as she should, if something like this happened. So where is the reprimanding language towards the Commonwealth, towards Proctor, for what's happening here? Maybe it's coming later. On April 10th, 24, Lally filed a certificate of compliance indicating the best of the Commonwealth's knowledge, he disclosed all the information. When defense counsel reviewed the Sallyport footage, they saw that the 42 minutes of the footage was missing. How does Lally not see that? The defense raised the issue with the court days before the trial was going to begin in April of 24, arguing the missing footage was critical to their theory. Commonwealth explained that the footage was intermittent because the camera was motion activated. Trial began on April 16th. First day of the trial, of evidence was April 29th because for jury selection. That gives you a good idea, by the way. It took about 2 weeks. Now we're giving over 3 weeks from April 1st to April 25th to when they actually want to start. And with all the extra publicity because of trial one and because of everything that's happened since trial one, I think it's probably going to take longer than the 2 weeks it took the first time. Lally received footage of the Sallyport interior back wall on April 17th, which had been looking for continuous camera footage of the Sallyport on the relevant date on April 23rd. Lally provided it to the defense. Why did it take him 6 days? Anything to say to Lally about that? Anything to say to the Commonwealth? Maybe that's not how you should do it. Maybe if you get it on April 17th, you should turn it over on April 18th. The images contained in this footage were inverted. Buchanan testified on June 5th and 6th. Lally showed it to him. Because the video was inverted, what appeared on the screen was the right side, was in fact the left side. Direct testimony did not alert the jury. Hey, here we go. She sees this as a fact. The direct testimony did not alert the jury that the video was inverted. But on cross, the defense questioned Buchanan extensively about the inverted image. So again, by doing a good cross-examination, the judge is basically saying, you've cured any issues. You've cured any problems. Nothing to see here. Nothing else we need to do here. The CPD began a review of other video surveillance footage in an attempt to explain the inverted images. As part of the process, CPD Rafferty reviewed surveillance footage from the cameras in the hallways and the parking lot in the early mornings of January 29th. Prior to O'Keefe being in the snow, the rear lot cruiser side camera had recorded ATF agent Brian Higgins, a witness called by the Commonwealth, walking across the parking lot, holding a phone near his face at 1:34 a.m. Notice what she doesn't say. She doesn't say taking a phone call. She doesn't say making a call. She doesn't say talking to somebody. And we're going to get into why this is such an issue as we go, because technically speaking, literally speaking, as a lawyer, words are important, definitions are important. She's correct. He's holding it near his face. He could be doing a lot of things, right? He could be using it as a flashlight. He could be on FaceTime, on the phone. He could be, I don't know, using it to warm his face if the battery was warm. Sure, he could be doing lots of things. How do we get that answer though, right? It's not a mystery. It shouldn't be. In September of 24, Special Prosecutor Brennan joined the team. On October 10th, he provided the rear lot cruiser camera footage, other surveillance video to the defense. On November 8th, the defense emailed Special Prosecutor Brennan requesting all raw video footage, which shall not be limited to the cameras capturing the interior or exterior of CPD, including all parking areas, garages, etc., etc. He said that he would try. Brennan asked all associated law enforcement for the files. During the process, he came into possession of the main driveway exterior footage originally obtained by Proctor in June of 23 and not previously turned over to the defense. The judge is now even throwing Proctor under the bus, but not any nasty language just yet. But clearly saying, I mean, this is fireable, in my opinion. Without the text message, without the other stuff, if you're a lead investigator and you're doing stuff like this in a investigation where a cop lost his life, this is a fireable offense. But that's just my opinion, if I was the decision maker. On January 28th, the Commonwealth turned over the main driveway side exterior Sallyport video to the defense. As noted above, the footage shows the exterior of the Sallyport when the defendant vehicle was brought into the CPD garage. But the quality of the recording is, as noted, poor. So this is another area where the Commonwealth gets the benefit of the poor quality of the video. Defendant's arguments. The defendant argues that the Commonwealth provided an untimely disclosure, withheld or destroyed certain CPD video in violation of Rule 14, Brady, and the court's preservation order. She further contends that the timing and the quality of the video footage that has been produced demonstrates the Commonwealth sought to intentionally deprive the defendant of exculpatory evidence. According to the defendant, the Commonwealth's conduct was so egregious, dismissal is warranted. This argument is flawed in several respects. Now we get to hear what the judge thinks about that argument. First, contrary to the defendant's argument, there was no court order requiring the Commonwealth to preserve or produce the CPD surveillance video before the first trial. So she clearly disagrees that when they asked for everything, they meant the video. The order required the Commonwealth to preserve all physical evidence, including anything present on or near the defendant at the time his body was discovered, anything found at the alleged crime scene. This order did not extend to the surveillance footage of the CPD. So she doesn't see all physical evidence as including video of CPD. You can see it either way. From my perspective, you're vague and overbroad as a defendant or as an attorney on purpose to try and include things like this, but that's how she reads it. Regardless, that shouldn't matter because it did exist and it was downloaded. So why was it not turned over immediately in October? But we'll get there. Mass case law reflects a clear distinction between physical evidence and video surveillance footage. As no physical evidence connected the defendant to the crime scene, Commonwealth relied on the surveillance video to prove the defendant's identity as the shooter, characterized evidence of the defendant as communication, surveillance, and physical evidence. Commonwealth's evidence included numerous witnesses, including the victim and expert witnesses, as well as all physical evidence, surveillance video, and photographs. I would disagree that that is a clear distinction, but that's an argument for another day. Moreover, where the physical evidence described in the preservation order was further defined as including anything present on or near the decedent at the time his body was discovered and anything found at the alleged crime scene, the order cannot reasonably be interpreted as including video surveillance footage from the police station. I think it could reasonably interpret it either way, but regardless. But on October 5th, the motion to compel the discovery also did not require the Commonwealth to produce any CPD surveillance video to the defense. The order required the prosecution to produce evidence of all crime scene photographs and or videos taken in connection with the case. So even though it had the car and it had the surveillance and it had the tail light, still, they would have had specifically to ask for video surveillance footage that they could not have known existed. And this is where the interest of justice should come in. You have to turn it over now. Give me a break. All the discovery questions, everything that came out, everything that was asked about. We had an entire trial talking about this and they still didn't turn over all the video footage. This to me is finding reasons to end up at the conclusion you want to end up at. This is not the end of the inquiry, however. The absence of a court order requiring production of the CPD surveillance does not foreclose the possibility that production may still have been required under Brady and or Rule 14, aka interest of justice. The defendant contains that the prosecution should have inquired of the CPD if any footage existed and then produced all the footage because she maintains that it contains exculpatory evidence. Specifically, the defendant argues that the footage shows Proctor approaching the taillight in a manner that she says supports an argument that he tampered with the evidence, assuming without deciding that the footage is actually useful to the defense. Dismissal is not warranted because defense counsel actually used this evidence to advance the tampering theory at the first trial and can do so again at the retrial. So how does she get there? She's not going to agree that it looks like Proctor was tampering, but she's going to say, if that's your argument, assuming it's true, you were able to make that argument. Therefore, you were not prejudiced because they didn't turn over the video. Again, I do this for a living. I try cases. I will tell you, when I have time to prepare, I am so much better than when something is thrown on me. Still pretty good when something's thrown on me. Most trial lawyers are. Compared to your average person, the people that end up in this profession are usually pretty good at thinking on their feet. But we're also very good. We spend most of our life, right? Because trials are less than 10% of our cases, preparing, thinking about things, coming up with angles and arguments. So if they would have had this video right after it was asked for by Proctor in February of 22 and June of 22, it's crazy to think that they wouldn't have been able to do a better job in the defense. And to say, oh, you remedied it because you got it in the middle of trial, you were able to use it. But that's how it's done. Now, frankly, again, while I disagree with some of the reasoning, I understand why she didn't dismiss the case. I think that there are other ways. There were more important things that could have happened, like bringing in the jurors and questioning them. Did you actually vote not guilty on 2 counts? Okay, then I'm going to dismiss those 2 counts as a judge. I think she should have done that. If I was a prosecutor, I would have declined to prosecute because of all the investigative issues and because of potentially the jury vote. I would have wanted to talk to the juries to see what they said. So those were better opportunities to get rid of this case than a motion dismissed because a second trial is already pending. In addition, while the current Rule 14 makes clear the Commonwealth is required to close the defense as investigative materials, video, and audio recordings in the possession, custody, or control of any member of the prosecuting team, so she admits that's how it is, the rule in effect at the relevant time period has no such requirement. Isn't that nice? So again, we're throwing the interest of justice out. We have literally changed the rules here in Massachusetts to include that, probably because of this case. But at the time, we didn't have it. No harm, no foul. Nor did the Rule 14 in effect at the time clearly state prosecutors' duty to inquire whether such evidence exists. Isn't that nice? Because the defendant made no specific request for the Commonwealth to produce such evidence until and after the first trial, it is not clear on the record how or when the Commonwealth should have known that the surveillance video was germane to the defense. I mean, come on. Come on. Half the trial was about what the cops were doing when, what happened to the tail light. I mean, that's just wild to say, well, when could we have really said that this was relevant or important to the defense? Come on. Until the Commonwealth knew, for example, that the defense's theory included that law enforcement tampered with the taillight while it was at the Sally Port, or that Higgins was a proposed third-party culprit, it had no reason to inquire as to whether any relevant video footage existed. But we can all agree, by the time the first trial started, they knew that, and they still didn't turn it all over. The first trial ended, and they still didn't turn it all over. It's not to say the Commonwealth had no duty to turn it over. Well, that's nice. The production during the trial was undoubtedly late. Oh, you think? And here's what's annoying. It's like she can look back and be like, oh, definitely late in the first trial, but now we have the second trial to fix all it. We knew it was late during the first trial, and dismissal was not considered at that point. Prosecutorial misconduct was not considered by the judge at that point. However, the defendant received the video more than a month before it was submitted into evidence. Oh, wow. How much? Look at that time. And because she had advanced no argument as to what, if any, her counsel would have done differently if the disclosure had come earlier, the defendant has not shown she was prejudiced as a result of the late disclosure. In determining the consequence of the disclosure, we asked whether the defense was materially hurt in its preparation by having to meet the unexpected evidence. Yeah, that would have been a good thing to argue, is how you would have used it differently. Okay, here's the footnote I want to read. The defendant also argues the rear lot cruiser side camera footage should have been turned over because it was exculpatory impeachment evidence that the defense could have used to show Higgins perjured himself before a federal grand jury when he testified he did not call anyone on the night in question. Seems pretty important. That argument fails for several reasons. First, it's not clear how, within the bounds of the admissible evidence, the defense could introduce evidence of this alleged perjury at her criminal trial. Really? We acting like that's not going to come in? Second, even a cursory review of Higgins' grand jury testimony reveals he said that. Okay, we don't know what that says, so that makes it tough to see, is it really perjury? Third, the video at issue, a 4-second silent clip showing Higgins walking across the parking lot, holding a phone near his face. So she admits it's even near his face, right? It's not like he was just holding it out in front of him or down at his side. Does not clearly show, as the defendant represents, the witness speaking to some unidentified individuals on the phone. See defendant's memorandum at 10. The clip does not reveal how Higgins is utilizing his device, and it in no way establishes that he perjured himself before a federal grand jury. Finally, in this regard, the remedy for non-production of this video clip is not dismissal because the defendant's rights are fully protected by her ability to use all this at the retrial. And that's the catch-all. And frankly, that is a legal catch-all. Because the remedies would be a new trial. Like if Karen Reed would have lost and this was on appeal and this happened and they were like, you win, we're not going to dismiss the charges though, retrial is the appropriate remedy, everybody would probably be okay with that. Or not everybody, but legally speaking, that would be appropriate. So I understand where Judge Cannone's coming from denying the motion to dismiss. I just don't agree with her factual findings and reasoning throughout this entire order. She could have simplified it and made it much easier. Here, I'm thinking, why didn't we hold an evidentiary hearing and call these witnesses? Why didn't we ask Higgins? Did you talk to somebody on the phone and let him bring his defense counsel and plead the fifth and not answer? That would have been helpful to the defense in this motion to dismiss. With respect to the main driveway side exterior Sally Port camera, even if Proctor should have turned it over. So she still won't put in here that she believes Proctor should have turned that over. That's wild to me. The quality of the footage is so poor that it's impossible to tell the condition of the taillight or how close anyone is to that right taillight. So the defense couldn't have used it because the condition was so poor. So again, the Commonwealth benefits from that. The defendant also argues that the Commonwealth has violated Rule 14 by failing to preserve all of the footage with the metadata. There is no merit to this argument. The defendant did not make any specific request for the original footage with the metadata before the trial or before it was overwritten. And that, again, is just one of the many reasons defendants start so far behind the eight ball. We don't know stuff exists. And then when we ask about it, by the time we ask about it with the properties we want, they have made sure those don't exist. So we can't even go prove if they've edited anything, messed with any. And I'm not even talking about this case. I can't tell you how many clients I've had that say those recordings are edited. That video is fake. And sometimes I'm like, yeah, right. Come on. But other times it's like, that could be legitimate. And guess what? You'd be shocked how many times we look at it and we're like, yeah, we can't prove it now because of how the internal system of the law enforcement works. Nothing in the version of Rule 14 then in effect that or the current version that entitles the defendant to the metadata or log files underpinning surveillance footage in the possession of the Commonwealth, and the defendant has not directed this court to any authority suggesting preservation of the evidence is required. That's new age stuff, right? We need to update our rules. The legal rules are always behind tech and behind those advancements that are being made. I know when we talk about it, I'm trying to push that stuff. There's a lot of people of a different generation in there that think, no, that makes it more complicated. And so we battle it out, and eventually it takes years for any of these changes to happen. And by the time those changes happen, the tech has updated again. Nor has the defendant demonstrated the metadata would have been exculpatory evidence. How would we demonstrate that without the metadata, right? And again, I'm just thinking of this case as just me and cases we've handled and that our office handles, the people that still do criminal defense in our office, and how one of the reasons why I hate practicing criminal defense is it is so unfair. It is so frustrating. It drives me up a wall because I'm so type A. So I'm better as a advisor to the other lawyers in the firm, bouncing ideas and angles of ways to make argument. I can't live in it because it makes me so mad. It makes me so mad. The lack of leverage you have, especially compared to a civil plaintiff attorney. We have the leverage. We're pushing, we're putting the pressure on, and there are rules that protect civil defendants, and we battle it out, and then we go to trial and it's all about money. But in the criminal case, it's like you're putting your life on the line, your liberty on the line. And if one side's being unfair, the leverage is just not close, and you're seeing many of the reasons why. A defendant who seeks relief from the loss or destruction of potentially exculpatory evidence has the initial burden to establish a reasonable possibility based on concrete evidence rather than a fertile imagination that access to the evidence would have produced evidence favorable to his cause. And you can imagine a lot of these are far stretches, and if we didn't have a lot of the other information we have in this case, many cases we'd be like, yeah, that probably wouldn't have helped them anyways. Truly, we don't know in this case, right? They must establish a reasonable possibility that the loss or destroyed evidence was in fact exculpatory. I agree with that. That is true. And this is why this is a losing argument. It's frustrating. It's unfair. You can understand how hard it is for a criminal defendant, but legally speaking, it is a losing argument. And they say, or she ends it with, well, the remedy is a retrial. Withholding of exculpatory statements of Jen McCabe, May 7th, during the first trial, defense produced reciprocal discovery to the Commonwealth regarding location information of McCabe's cell phone. She was at Lank's house in anticipation of her trial testimony. Commonwealth met with her. McLaughlin, Tully were present. Tully asked McCabe why her cell phone would have been in Lank's house. She answered him. They were picking up the daughter. Commonwealth did not turn over the substance of this conversation to the defense prior to McCabe taking the witness stand. Tully wrote a brief report, but it was not produced until May 29th to the defense. That's a problem, obviously, that entire timeline. Jackson crossed McCabe. She explained she went to Lank's house. Jackson questioned McCabe why she didn't report that fact. And when she met with one of the first reporting officers, he further questioned her on the length of the conversation, who else she talked to, where she was during the conversation, if she went to the house. Again, him doing a good job and thinking quick on his feet, being held against him now for what the remedies could be. During cross-examination, Jackson also questioned McCabe about the details of her discussions with Lally, McLaughlin, Tully. She testified that when Tully asked her if she went to Lank's house, at first I said no, I've never been to his house. Then I thought, and I said, oh my gosh, yes, I did go there. That was the extent of the conversation. After the defense received the report, Jackson raised the issue with the Commonwealth's failure to disclose her testimony, which during trial, the Commonwealth interviewed Jen McCabe, apparently had a full interview with her. Tully took a report, dated the report, and then the Commonwealth held on to that report until after she testified. Interview, the report, and the completion of the report were all done before her testimony. To me, these are just indications of huge problems. And this is one I don't even mention sometimes when I start just spewing off and listing all the problems. This is one I don't mention. This is one that if it happened to me on one witness in one trial, I would just explode very calmly and professionally to the judge and explain how we just can't possibly do things like this. If the people of our county knew that this is what was happening in trials, they would not be happy. Everybody knows in this case. The court offered to allow Jackson to call McCabe back to the witness stand. No, Your Honor. And here again, you knew this was going to be held against him. I'm not. That's not. The court understands, not my point. Don't call her back. I've done the damage that needs to be done to Jennifer McCabe. Jackson repeated, I've done the damage that needs to be done. Defendant's argument is now that violates Brady and Rule 14. She gave a false statement. And again, because we have a retrial, we know where this is going. Commonwealth therefore should have provided McCabe's statement. However, defendant cannot reasonably claim that she suffered any prejudice. On cross-examination, Jackson questioned her about this, and then he got another opportunity to question her, and he declined. So he was offered a remedy, he declined. So that is the right decision by Judge Cannone, in my opinion. There you go. She made the right decision here on this motion. That should not be a reason for dismissal, but it should be a reason for everybody to take a look and be like, this is bad. This is bad. This is not how an investigation and a prosecution is supposed to go. The remedy for discovery violations, as noted repeatedly herein, the defendant has not demonstrated she suffered any actual prejudice with the late disclosures. However, even if the defendant was able to show prejudice, the appropriate remedy would not be dismissal. Dismissal with prejudice is a remedy of last resort. We've read this. Sanctions must be remedial rather than punitive, aimed at curing any prejudice caused by the violation of a discovery obligation. The bar is so high for dismissal that it gives judges the opportunity to just say new trial, and there's already a new trial coming here. Imagine if she got convicted. It would be such a big deal to get a second trial. And that's basically how the judge is looking at this. And that's basically how all the case law contemplates it. If somebody was convicted like this, give them a new trial. That's a big remedy. But to go and dismiss charges they were already convicted of, you can imagine how crazy that would be. And that's how a lot of this case law is built around the country. Nor has the defendant shown the Commonwealth's conduct was so egregious, deliberate, and intentional that prejudice should be presumed. Such a theory should be narrowly applied and confined to situations where the misconduct has cast such doubt as to poison the entire investigation, and a strong deterrent is warranted to prevent repetition of such misconduct. So to me, that is the defense's best argument. This was so bad, prejudice should be presumed. We should not have to argue, we would have done this different. We should not have to argue, I would have asked these questions on cross from McCabe, now knowing, having a time to actually ponder what was turned over late. They shouldn't even have to do that because this was so egregious and bad that nobody can trust this investigation. That's how I feel. I feel like I'm pretty even-handed. I like cops. I trust cops generally. I like prosecutors. I trust them generally until they give me a reason not to. And in this case, that well has been poisoned to the effect that you just can't take what they say. I should say, I'll speak for myself. I can't take what they say as truth. The facts before the court do not depict a concerted and intentional attempt by the prosecution team to deprive the defense of discovery, which would have aided her case. Even if the defendant were able to show that the conduct at issue here was part of members of the prosecution team was intentional, the remedy would be a new trial. So even if it was intentional, which is crazy, like if they could actually prove that, Proctor actually tried to destroy that file, but it didn't work. And then, so he was trying to hide it and it didn't work. She's saying, even if you would have proved that Lally was like, no, don't give me that. If Lally told him that, she's like, even that, I wouldn't dismiss the case. That's wild. That's where I don't agree with her, right? I get where she got, but she says things like this where even if it was worse, I still wouldn't dismiss it. It's like, wow. Whether an indictment should be dismissed upon the defendant's motion where the prosecution acted improperly turns primarily on the ability of the defendant to obtain a fair trial and in light of the impropriety. So it's like, how can she get a fair trial with this horrible investigation, these messed up videos, all this internal affairs garbage, all this stuff happening that's impeaching these witnesses? Like, really, we can call it a fair trial? In this case, the defendant's rights of disclosure of evidence pursuant to Brady and the rules of criminal procedure are fully protected because no verdict was returned at the conclusion of the first trial and a retrial is about to start. She suffered no irremediable loss of any constitutional right, and her motion for dismissal on these grounds must be denied. Interference with the jury. And this is perfectly to segue us into Karen Reed's new defense lawyer. There are two issues arose with the jurors. First, on June 14th, where Juror A reported to the court Juror B had made comments about the evidence and the defendant. The court called Juror B to sidebar and questioned her about what she had said and if she could keep an open mind and consider the evidence in a fair and impartial manner. Despite the representations that she could, the defense expressed concern about the comments that had been one-sided against the defense and asked that Juror B be excluded. The court then inquired of Juror A. Juror A stated Juror B made comments about the defendant's facial expressions during trial. The court then questioned two other jurors whom Juror A said were sitting close by Juror B. Both jurors said they had not heard what Juror B said directly, but that Juror A had mentioned it to them. Court then called back Juror B, who denied making any negative comments. The court has omitted identifying information of the jurors. Okay. After questioning the jurors, the court consulted with counsel. The Commonwealth expressed that if the court struck Juror B, they should also strike Juror A. The defense disagreed as to Juror A. The court ultimately decided to dismiss Juror B from the jury. On June 25th, before closing arguments were scheduled, the court received information from court security that another issue involving Juror A, A member of the Massachusetts State Police had contacted court security to say they received information that a juror thought to be Juror A was at one of the local posts for the American Legion talking about the case, and there may be a recording of her doing so. At roll call for Dedham Police on the morning of June 25th, a number of officers confirmed they heard similar things about the juror. Yikes. The court called a sidebar to discuss. The defense counsel asked for the name of the MSP who received the information. Fanning is a supervisor in the Norfolk County Detective Unit. During the investigation, he was Proctor's supervisor. He was also one of the recipients of a group text circulated by Proctor that included reference to looking for nudes on the defendant's cell phone, as well as reference to defense counsel's client phone. Defendant's Exhibit Q. Defense counsel represents, and for purposes of this motion, the court accepts that Fanning also interviewed some witnesses in the case. Fanning was not himself a witness in the trial. Sounds like some connections from Fanning, right? Which everybody want to say nothing to see here. It's like, sounds like even the court sees there's some connection here. After explaining to the attorneys the situation, the court called Juror A to sidebar. Following exchange occurred. It's been brought to my attention that you might have been out recently at the American Legion or Knights of Columbus or someplace like that in Dedham, and that someone has reported that you have been recorded talking about the case. That's the information I received. What can you tell me? I don't know. Have you been at the American Legion? Like a month ago. Okay, at the time, were you talking about? No, not that I remember. Not that I remember, no. Do you remember if people were mentioned to you anything about the case? I was drinking. I don't remember. Okay, the further information I have that this morning, several Dedham police officers said that they heard the same thing. Okay, all right. Could it have happened? I don't know. Okay, I really don't know. The court asked the juror to step aside and then discuss the matter with the attorneys. Commonwealth expressed concern that the juror had been involved in the previous issue and requested the juror be excused. Defense objected that the previous incident was unrelated. Focusing on the instant incident, the court conveyed a concern that the juror did not deny incident, but instead stated she had been drinking. The defense responded to the court should consider that no other juror had been affected and that the source of the information was a Massachusetts State Police officer. Therefore, a discussion about Lieutenant Fanning ensued, with defense counsel suggesting Fanning and the Massachusetts State Police had been targeting potential jurors for the purposes of trying to get them excluded from the jury. The court allowed defense counsel to make the argument about why the court should not dismiss the juror. So if you remember, when defense counsel made this argument at first, it was like, man, what are they really talking about? What are the connections? A lot of things were redacted. It's like, well, juror A said something that may be positive for Karen Reed. She got a juror struck potentially by ratting on a juror for doing something they shouldn't have been doing, which was bad for Karen Reed. The Commonwealth wanted her out. They weren't able to get her out. So then a bunch of cops come and say she said something that they know or should know could get her cut, including a well-decorated and respected officer, Fanning, who's also Proctor's supervisor, who's also interviewed witnesses on the case. To me, if I was the judge, I would be like, Fanning should not be involved in this at all. Like, come on. Lawyers should know about the appearance of impropriety. Come on. Like, this is crazy to me that this happens. This is wild. Reading through this is the first time I really had the full connection of how all this worked. Fanning is the commander of the extensive security operations that this case has required. What occurred is he received the information. He did not investigate. He had no evidence of any crime. If he did investigate or reach out to anyone, that could have been considered an improper influence on the jury. What he did is reported it to the chief of the trial court security to make the trial court aware, as it is simply a trial court issue. That's what the district attorney argued. The court then conveyed its decision. I believe there is credible evidence that this juror has had conversations about this case. She did not deny it. I find that there have been violation of the court order for failure to report it on a repeated basis. Jury had no problem reporting the other juror, but then at the time also did not tell us that she spoke to the two other jurors I inquired of. She told us they may have overheard, and then it was another juror identified by seat number who ultimately told us that the juror had reported to her what the other juror had said. Juror A may not remember whether she spoke about this case, but I wouldn't be surprised if she remained as a juror if we did hear from somebody who was at the VFW that night after all of this. So for all those reasons, I'm going to excuse her from sitting on this jury. At this point, the sidebar conversation continued about Lieutenant Fanning. McLaughlin said, what I said was that Lieutenant Fanning is the unit commander of the security operations, which I know from personal the past 3.5 months, that's his role. Attorney Little said for the jury. The court said, hold on, not for the jury, for trial support and security. Includes overseeing the jury. But there's a lot of smoke around juror A, right? So that gives the judge the opportunity. But how did the smoke come? First, she reported a problem she saw, and then a bunch of cops were like, she's talking about it. It's dirty. It's dirty. I get how it happened, but it's dirty. Defendant's arguments. Criminal defendant is entitled to a trial by an impartial jury pursuant to the Sixth Amendment. Defendant here argues it was violated when the court dismissed juror A. According to the defendant, the court dismissed juror A improper based on the juror's views of the case. Specifically, the defendant contends that juror A appeared sympathetic to the defense. Therefore, MSP, who have interest in the defendant being convicted, targeted the juror to get her dismissed before deliberations. Do you know why the defendant can argue this? Because all of the witnesses against this juror were cops. I mean, that's not like, wow, the defense got lucky that that's what happened. Because first off, the court usually believes cops more than just lay people. That's a problem. The defendant's first argument relies on a significant claim to clairvoyance about juror A's sympathies at the time of the sidebar conference, and it is premised on unsubstantiated claims regarding Fanning's involvement with the jury, despite being specifically informed at sidebar that Fanning was not in charge of security for the jury, and without providing any evidence that Fanning ever interacted with any member of the jury. Defense counsel repeatedly claims, without any evidentiary support throughout their memorandum, the present motion, Fanning was commander of jury security. In fact, and as made clear to defense counsel at sidebar, Fanning was the commander of security operations during the trial and not in charge of the jury. But Fanning sure as heck had something to do with juror A getting cut, right? I mean, it seems like we all agree there. Fanning's role at the first trial related to significant and unusual security concerns caused by large crowds in the immediate area of the courthouse. To ensure the defendant's right to a fair trial with an impartial jury, free from outside influence, the court instituted a buffer zone around the courthouse during jury selection. MSP and local police, okay, they had to do it. Trial court's responsible for jurors, court officers employed by the trial court, and only those officers are in charge of the jury. Those are the people that had access to the jury, not Fanning. Counsel's claim that he was in charge, was directly involved, is simply false. It is, of course, required that lawyers present only good faith arguments to the court under all circumstances, but the failure of counsel to take care with the truth of their assertions in this regard has particularly damaging consequences. So after all that about Proctor, after all that about Lally, after all that about the Commonwealth, no negative language towards the Commonwealth or the cops. But she says basically the defendant knowingly lied about Fanning's connection to the jury, and that has particularly damaging consequences. This case has generated substantial public interest locally and nationally. By the way, never any reprimand about, I heard rumblings that ARCA was getting some nasty comments and people going after them because of what's going on in this case. No mention of that. To suggest without factual support that an MSP officer had influence over the court and the jury in the first trial is to invite unwarranted public speculation and distrust about the integrity of the Massachusetts judicial system. Frankly, they didn't have to say it. They could have just given us exactly the step-by-step timeline of what happened, and I think most people would be like, that's dirty. It can also be seen as improper attempt to influence potential jurors in advance of the retrial. Thus, the court takes the opportunity to make clear that neither Fanning nor anyone else from the MSP interacted with members of the jury or influenced the court's decision to dismiss juror A in any way. So she's saying that Fanning and the other cops saying that this juror spoke out did not affect the court in any way? How can that be true? That's part of her findings. She found that the jury didn't deny what the cops said she did, speak about the case outside the courtroom, violating the court order. She found that the juror violated the court order. How can you say the only evidence that the juror did that did not affect your decision in the case? I'm not following that. When Fanning became aware of the information regarding juror A, he turned it over to the court assigned to the case because it was a matter to be dealt with solely by the trial court. And you listened to what he had to say and other officers and made your decision based off that. So, again, you can do that. There's nothing wrong with a judge doing that. What's weird is she's acting like she didn't do that. The defendant also argues that the court failed to employ the proper process before dismissing the juror. This argument is based on an incorrect understanding of the law with respect to the process the court must undertake when presented with an issue of a sitting juror. A judge has discretionary authority to dismiss a juror at any time in the best interest of justice. I agree with that. But again, that's judge's discretion. That is what the case law says. When there's an indication that a juror is unable to perform his or her duties, a judge may properly discharge that juror. Where a judge has reasonable concern that a sitting juror cannot comply with a court order to not discuss the case, the juror, after the individual voir dire, may dismiss the juror. So she's saying she handled the process appropriately. It is within a judge's discretion. When alerted that juror A might have been talking about the case at American Legion Post, The court explained the situation to the attorneys, then called the juror in for questioning. Again, it seems like she's acting on what Fanning and other officers told her. Juror A did not deny that this occurred. Rather, she didn't remember. Court then heard from argument from counsel. In deciding this matter, the court considered Juror A's equivocal answers to questions about the incident. Okay, the court considered the American Legion Post incident to be a second failure of Juror A to comply with the court's order not to talk about the case. Based on the totality of circumstances, court decided in its discretion to dismiss Juror A. That to me says you took what the cops and what Fanning said, and that did affect your decision. Like, she's admitting that here, talking about it. You can say they didn't have contact with the juror, fine. And frankly, I think that the process was good enough. The problem is cops intimately involved in the case were the ones pointing the finger at this juror. That should have been revealed, known, discussed, and potentially the testimony of those cops should have been diminished because of that, just with the appearance of impropriety. Defense cites several cases in support of their argument that post-impanelment, but pre-deliberation, if a judge is alerted to potential misconduct of or affecting jurors, the judge first determines whether the material raises a serious question of possible prejudice. If she so determines, she must then hold a hearing to inquire further. Based on the cited cases, the defendant argues the court's questioning of Juror A was insufficient. The defendant, however, misunderstands the law. First, the cases cited are in opposite. Primary case relied on concerns information the judge received about a claim of extraneous influence on a juror, with the co-defendant counsel raised after the jury had begun deliberations. The other cases cited by the defendant also concern the potential discharge of deliberating jurors. These are the cases they cited. Defendant also fails to cite any authority suggesting, as she contends, that the court was required to engage in an evidentiary hearing with Lieutenant Fanning before deciding whether to dismiss the juror. I think that would have been best practices. The court here called Juror A to sidebar, conduct an individual voir dire, and she argues handled it appropriately. Therefore, this motion to dismiss is denied. Whew. Okay, let's get to some questions, and then we're quickly going to get to the lawyer joining the defense team. I'm extremely disgusted by this, so having to pay for a whole second trial is not biased. The remedy is a retrial. Everything is stacked. Paula Z, am I obsessed with this case? I'm on a cruise, just came back to my cabin for a day, from a day in St. Thomas, and joined this live. Thank you, Peter, for all the work you've done to provide such incredible updates. That's awesome. I'm jealous, Paula. I'm jealous. I got to be honest. Peter, how different do you think this case would be with Judge Doro or Judge Everett? Extremely different. Extremely different. To making it count. Yet again, Bev does not allow an evidentiary hearing in trial 2.0. No matter what, Bev will kick the can, citing shoulda, coulda, woulda versus remedy prior to trial 2. Nevertheless, the botched investigation. Let me see. Yeah, if only Bev could have a hearing and find out. That would be nice. That would be nice. Peter's trying hard to keep the Karen Reed fan club happy. Am I? Because it seems like both sides come at me all the time. Both sides come at me all the time. I read things how I see them, and you get like my instant reactions. That's what you get. But it's always funny to see how people view things. Anti-Bev, even if there was proof beyond a shadow of a doubt, I would not dismiss this case. Why can't Bev be investigated for her obvious bias? Peter, I'm surprised a lawyer made it to the jury in the first place. Are you? Yes. And we've talked about this a little bit. And let's take a second and talk about it now some more. So I'm going to pull up here Turtle Boy's announcement that Victoria George, he said, just when this story can't get crazier, Karen Reed has added attorney Victoria George to her defense team. Victoria was a juror in the first trial who was made an alternate on the final day after making faces throughout the trial, indicating her disgust with the Commonwealth. There's no doubt about it that this lawyer ended up, in my opinion, seeing that this should have been not guilty. Let's take a look here at what Christina Rex said. This is on March 5th, right? So like 3 weeks ago. This is a statement released by Victoria George, an alternate juror from Karen Reed's first trial. She's also an attorney and has given me permission to share the statement, which is her reaction to today's hearing. I was a fair-minded juror who left this trial questioning the integrity of the system long before the defense filed a motion to dismiss with allegations of jury tampering. It is the Reed case itself and the fact that it is still being brought that has left many in Massachusetts wary, distrustful, and scared of our system. As a lawyer, this reality saddens me even more because I remember how much faith I had in our system as an optimistic law student. Mr. Brennan made an impassioned argument today regarding his alleged concern, some might be questioning the fabric of our entire judicial system. If he truly would like to address the problem, I have a few suggestions. Perhaps the Norfolk County District Attorney's Office should be more focused on remedying the systemic issues plaguing it and affiliated police departments rather than continuing to spend millions of taxpayer dollars prosecuting a case with so many evidentiary issues that it calls into question whether they are even following their ethical obligations as prosecutors. The Commonwealth has a duty to protect the rights of defendants, and I, for one, would love to see them do so. So this is somebody who sat down as a juror on this case. And to me, both sides usually don't want a juror. She's not a criminal lawyer. Well, now she's in a very big criminal defense case because she's joining the criminal defense team. But that's probably how she ended up. My first thought is, ain't no way the Commonwealth's going to want any lawyers on the jury for trial number 2. And I don't know that every juror would be good for Karen, or every lawyer. Did I say? I don't know what I might have said juror on the jury. I mean, lawyer on the jury. I don't know that every lawyer would end up on Karen Reed's side, but I know lawyers usually really understand reasonable doubt, and it frustrates them when things like this happen and the Commonwealth doesn't do necessarily what they should do. Also important to note that I'm sure there have been allegations that she was a plant on the first jury. Good luck planting somebody to do something illegal that has their bar card and makes their living as a lawyer, right? It's not like you can hand them 10 grand and they're like, yeah, I'll do it. Runaway jury style, right? I don't think that's what happened. This should speak volumes to the public that she is joining the defense team after being so unbiased. Like, this is how unbiased she was, okay? Because everybody can argue I'm biased and this person's biased and whatever, and they will, and that's fine. This juror was so unbiased as a lawyer that the Commonwealth picked her to be a juror on trial number 1. They could have struck her, and they didn't. She's now a Yannetti law firm attorney. Oh my gosh, what is happening? What is happening? How did all this happen? This is interesting. This is also one of the times, well, never mind, I won't say it. It's one of the times that it's interesting to be doing what I'm doing in this process and understanding certain things in the background of this cases that just makes it so interesting. So interesting. Nina said, is there a legal issue with her joining the team? So this is also a question that I've gotten over and over again. Here's my answer. I can't think of one. I have never contemplated this issue before, but I can't think of one. She didn't represent John O'Keefe or the Commonwealth or the McCabes or the Alberts or anybody that would put her really in a conflict. She obviously didn't have any information in this case prior to. I can't think of a legal reason to block her from representing Karen Reed. Judge Summer would have likely dismissed, to be honest. If not that, then she would at least have granted their requested hearings. Yeah, I think she would have done things a lot very differently. But I think that it is a bit of a different analysis because we have trial 2. And because all of this did not explode in the middle of trial 1. If it would have, some of it did. But if all of it would have, I think she would have dismissed it during trial 1. And if more were to happen in trial 2, I think at the first sign of something that wasn't turned over, she would dismiss it. I don't think Judge Cannone is going to do that. Is judicial bias waived unless the defense moves again? No, and again, I just don't think that's going to be their winning argument. I've said that all along, whether people like it or not, on both sides. I'm not trying to keep the Free Karen Reed fan club happy when I say that, okay? I'm just telling you honestly what I think, and I think whatever side you're on, you should appreciate that, you should take it, and you should do what you want with it, right? You don't have to agree with me. You can disagree with me. Come up with reasons why. I pay good money to see Peter ask Bev these questions. I don't think she would be interested. Kathy Lynn, always appreciate your lives. This is crazy. I'm from Mass. Yeah, honestly, if I was from Massachusetts right now, I don't know how I would feel. Actually, I do know how I would feel. I'd be like, we got to do something. We got to vote different. I got to talk to my legislators. I've got to talk to my judges. I've got to go talk to your state attorneys. You're allowed to do that. It's people. Write letters. Do things. Make a change. Ask for transparency. Ask what they're doing to make this not happen again in the future. John said, I don't know. I think it's a bad look for people inserting themselves into any case, not necessarily her, but anyone. I try not to insert myself in cases all the time. So I get what you're saying and where you're coming from. But this is so wild that I do think it's going to have a positive effect publicly. So I understand why the defense team is doing it. You can hold it against her if you want. And by the way, the defense team is not going to be able to say that lawyer sitting right there was a juror on trial number 1, and she joined our defense team because she believes in our defense so much. They're not going to be able to say that. That is not going to be evidence that comes out at trial. But it is kind of like the 13th juror being out there, right? I've talked about how we've done closing arguments in the past. My dad loves it. You know, one lawyer sits at the table the whole time and does not say a word or question a witness, and they get up and do closing argument. I've done it before. And you're like, I sat over there just like you guys listening to all this. And let me tell you what I heard. And you go through what you saw as the 13th juror being a lawyer making the argument. Netwoman, I was telling my bro-in-law about this case and my sister stopped me and asked what movie I was talking about. There's no way they'd believe you. I feel like Hollywood wouldn't make this movie because it'd be too unbelievable. I live in Norfolk County. I'm horrified. I get it. I get it. YouTube user, is she joining in case Yannetti gets kicked off? No, she's not going to be able to like pick up for Yannetti. She does not have from what I understand, she doesn't have the criminal defense experience just to get up and handle this case. She may handle a witness. She may handle 2. It may purely be for the headlines. Maybe she does nothing in the trial. I don't know. I think they probably should give her something to do in the trial so it doesn't look like they were just trying to grab headlines. But it is 3:31 and I have to go. But please keep the conversation going. Tell me what you think. I can't wait to hear and read what you think about Victoria George joining the defense team. From my perspective, I think she did come into this case unbiased, balanced, and I'm saying that because the Commonwealth picked her to be a jury. She left very seriously in one camp, didn't want to join the defense team immediately. This wasn't a plan, right? She could have joined them right after the first trial if she wanted to. She didn't. She could have joined them right after all the jury stuff was coming out. She didn't, but eventually she felt compelled to join the defense team, which is just so wild to me. So you guys let me know what you guys think. Make sure you hit the like button, please. I know I got to jump off and we had to keep it right at an hour, but I love you all. Thank you for being here. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.